Welcome back to the Supreme Court, where we're about to embark on the final lap of the hearing in the claimant in the FII group litigation against the Revenue and Customs. Mr. Ewart.
I was just about to move on to Section 85 and deal with that issue. And I think essentially the question here is whether it's permissible to provide a remedy demanded by EU law with a reasonable limitation period, which is what Section 85, of course, has. Can we just look at Section 85, which is 3053. It only applies to claims brought before 12 December 2012. As I understand the date was chosen, and perhaps you can see from the dates of the European Court decisions, it's 6 years after the decision of the court in FII 1, which was 12 December, I think, something like that. 2006. I understand that is the reason the date was chosen. There is another factor, which is that I think in around 2010, 2011, a provision was introduced into the Taxes Management Act and into the Finance Act 1998 in relation to recovering tax, which said, as the provision in VAT, which I think you looked at in Littlewoods and in ITC, there's a provision in VAT which has always said that you can only recover VAT by that statutory means. So you can't bring a common law claim. A similar provision was introduced into the Taxes Act provisions with it's hoped a limit. It was brought in with notice, if you like, something like 8 or 9 months notice was given that the provision was coming in, so a transitional period within the European Court jurisprudence. There has been some litigation about that in a case, Class 8 it's called. It's actually in the bundle, I think, the judgment. So far, the Chancellor, as he was then, Sir Geoffrey Voss, decided that the provision was valid, and therefore it blocked claims brought after the date it came into force. But that is not the reason for the 12th December 2012 date, I think. But I think the fact is it's thought that claims wouldn't be able to be brought anyway after that date. Now, the time limit is in subsection 2. It relates to payments on lawful ACT made after 1st January or in the period of 6 years immediately before the date of the proceedings. and that I think is the explanation for the fact that the dates in the interest table at the bottom go back to 1993, because there is a theoretical possibility that someone might have brought a claim, let's say in 1999, and therefore be able to go back 6 years from then. I think it's believed that there were no claims certainly before 1999, probably not before 2002, in fact. But anyway, that's why the interest rates go back beyond 1996. The date of 1st January 1996, or the 6 year period, I think is just regarded as being a reasonable period of limitation. In many cases, because claims were brought in fact in the 2000s, between 2003 and 2010, the period will actually be longer than 6 years. In practice. So we say that this provision doesn't breach any of the European law principles. It doesn't breach the principle of equivalence because there is no other better remedy in a corresponding domestic situation. But I'm not sure there is a remedy in a corresponding domestic situation at all. But anyway, there certainly isn't a better one. And it doesn't breach effectiveness because it is a reasonable limitation period, and no claims that were in existence were being taken away by the limitation period. It can't be right, as a matter of European law, that if a state is required to introduce a provision to grant a remedy, it is required to provide the remedy going back indeterminate period of time. We would submit that can't be a correct statement of European law. And for the same reason, it doesn't breach legitimate expectation, because claimants could not have a legitimate expectation to be able to bring claims in general going back longer than the normal limitation period of 6 years. That is, claims which are not based on mistake, this claim is not based on mistake, it's simply based on an unlawful tax charge. So we would say for those reasons it doesn't breach any European law principles. My learned friend raised the question of the 45% tax that is applied to restitution interest. And you find the provisions in Authorities Bundle 3 at EF 3971. And it's section 357YC, which gives the meaning of restitution interest. And it's subsection 4 that's relevant, because all of the conditions must be met for it to be restitution interest. You can see from subsection 1. Condition C is that the interest determined to be due, as mentioned in subsection 3, is not limited to simple interest at a statutory rate. And you have to look on further. No. I have to find, sorry, I'm trying to find YU. It must be right at the end. Yeah, sorry, it's on page 3987. It defines statutory rate, means a rate which is equal to a rate specified for purposes relating to taxation and in a provision made under an act. And so the revenue's position is that the interest provided under Section 85 does fall outside condition C. It is simple interest at a statutory rate. There is an issue, I understand, as to whether Section 35A interest falls within that definition or not. I believe the revenue's position on that is that it is not simple interest at a statutory rate, and therefore it does fall within condition C. I understand that is possibly under challenge, but anyway, that's not relevant to the point my learned friend was making. And as I understand it, this differentiation has been followed through. My learned friend referred to the Rhodia order, which I don't think we actually have in the bundle, but I've had a look at it. It does appear from that a clear differentiation is being made between Section 85 interest, which doesn't have restitution rate, doesn't have the tax on it, but the 45% tax, and Section 35A interest, which the revenue at least believe does. The validity of the Section 30 of this tax regime is under review by the courts. You may be aware the first-tier tribunal held that it was valid as a matter of European law. There's been an appeal to the upper tribunal, which was heard some time ago, I think, by well, Mrs. Justice Rosa, she was at that point, but not any longer. But before any judgment was given, the matter was stayed, I think, pending, well, prudential in this case, and because I don't know, it might all become academic, or at least much less importance. And certainly, where there's no compound interest on the secondary period, it's a lot less significant. In any event, that's the position there. So it doesn't affect who would submit Section 85 interest. Of course, it would be taxable at the normal corporation tax rates. It's not that it's tax free. So can I then deal with the final point I think my learned friend made on this, which is possible claims in equity? Now, I understand, and I take the point Lord Reid made, that we've been overruling cases more in this litigation than any other. But my learned friend's argument would require another case to be overruled, which is West Deutsche. That is in the bundle, actually, volume 7. It's tab 82, and the head note is at EF 5793. And perhaps you could just, if you just look at the head note and the holding as a summary of what the case was about. What everyone agreed about in this case, even the minority, is, and this is the orthodox position on the basis of hundreds of years of authority, I think, is that equity acts in an auxiliary role supporting common law remedies. So you can see in this case, the question was whether it would act in aid of the bank's common law claim for restitution. And the minority thought that was a possibility, that could happen, but it was only if it was acting in this auxiliary role. And both Lord Gough and Lord Wolfe make that point. So in any event, equity could only come into play if there is a common law claim. And I think both in Sempra, both Lord Walker and Lord Mance made the same point. That's volume 2, tab 15. And Lord Walker, you can find it at EF 3626. And it's paragraphs 186 and 187. And Lord Mance at paragraph 236. Where he explicitly makes the point that this would require a reconsideration of Westdeutsche and a departure from the decision. And you see at the end of the paragraph, he makes a point about the equity acting in aid of the common law or in a manner ancillary to it. So I think what they were envisaging was a claim, that there was a claim in unjust enrichment in common law, but that the remedy, the interest, the compound interest would be provided in equity, which meant it could be provided in a more discretionary manner than it would under a common law claim. That seems to be the thinking of Lord Walker and Lord Mance. But the underlying assumption is that there is a claim in common law in unjust enrichment. If there isn't a claim, then there's nothing for equity to act in aid of. So we would submit that recognising a claim for the first time in equity, a freestanding claim, it really would be a first. That would be probably one of the biggest decisions this court has made, even in this litigation. But we'd say it's contrary to, as I said, centuries of authority. And it would obviously require quite considerable consideration and argument if that was to happen. Unless there's any questions about that, I was just going to, the final issue I was going to deal with was just the summary judgments, very briefly. It did sound to me as though we were in a sense agreed on this, which my learned friend seemed to say at the end of his submissions on this, that the matter should be remitted back to the High Court. We would agree it should be remitted back, but it can't be on the basis that the summary judgments stand. They are actually, after all, final judgments, and they must be set aside, we would submit. And the matter is remitted back, and then the claimants, all of the claimants, including the summary judgment claimants, will get the appropriate remedy as worked out on the basis of this decision and all the other decisions that we've had in the GLO. There are, I may have forgotten to mention, but there are a number of other summary judgments that were granted by Mr. Justice Henderson. They were appealed to the Court of Appeal by the Revenue and have been stayed simply in the Court of Appeal pending this decision. I think the Court of Appeal took the view that there wasn't any, it would be a waste of time and resources to deal with them when this case was coming up. So they will have to be dealt with in line with whatever your lordships decide in this appeal. So unless you've got any further questions, I think those are all my submissions.
It doesn't look as though we have any questions for you at the moment, Mr. Ewart. Thank you very much.
Thank you.
In that case, we can turn to Mr. Aronson.
As to the timing, my learned friend has completed his submissions 38 minutes earlier than he could have done. Are we limited to our hour, or can we relax a little bit as long as we finish by 4 o'clock?
Well, I'm afraid his economy doesn't accrue to your benefit.
Oh, that was what I was just wondering. Okay, so we will restrict ourselves to the hour, and I will be as quick as I can because my learned friend, I think, probably needs some more detailed submissions than mine. May I begin by addressing Lord Hodges' question, which is there, and if so, what is the distinction between what Mr. Justice Henderson said about the Section 231 credit in the first series of litigations and the response on appeal of the Court of Appeal, which varied it? I don't know whether your screens have changed. Everyone has moved position. I was looking at Lord Hodges, suddenly dropped down. It's a bit like those memory cards you get for playing with children. Can you actually remember where they are? But I see where Lord Hodges now moved down to the front row. He's a striker at the moment. The answer to the question is there is a difference. It's a subtle and significant difference, and it was an improvement by the Court of Appeal. And I'll take you to the case just to show you. I was arguing in the early days that if we were right, then we simply treat the foreign dividend as if it's a UK dividend, and it will carry the tax credit in accordance with Section 231. Section 231 lays down a formula. It's a formulaic process for arriving at the amount of the tax credit. It's simply applying the ACT rate to the distribution. When the matter got to the Court of Appeal, and there was a disagreement of opinion as to what the EU law required, they varied that to say, no, you don't treat the whole of the dividend automatically as if it carries the whole tax credit, say at 25%. You see what credit EU law actually will allow. And they didn't know at that stage whether the ECJ was going to say you get the actual tax that was paid, or whether it's going to be a totally different sum or whatever. So that is the conceptual difference between the two. It makes actually in practice very little difference, but conceptually it is significant. And so the easiest way of looking at this is to just look very quickly at Section 231. That's at electronic page 3078. And you'll see subsection 1, we read it, subject sections 247, etc., where a company resident in the UK makes a qualifying distribution and the person receiving the distribution is another such company, or a person resident in the UK not being a company, the recipient of the distribution shall be entitled to a tax credit equal to such proportion of the amount or value of the distribution as corresponds to the rate of advance corporation tax in force. So that was what I was arguing for before Mr. Justice Henderson. And he thought that actually that was a sort of a very simple way of looking at it, and why not? And we find what he said about that at EF 1049. It's at paragraph 150. In paragraph 149, I had said in various ways you could have a conforming interpretation. 150, in my judgment, either of these methods would achieve the objective of ensuring that foreign dividends from member states are treated in the same way as domestic dividends for ACT purposes. And like Mr. Evanson, I slightly prefer the first method. It seems to be more in accord with the structure and philosophy of the UK partial imputation system to confer a tax credit on the relevant foreign dividends and then treat them as FII in the hands of the recipient. In other words, treating the formulaic 25% of the dividend as flowing through in section 231. And it was that the Court of Appeal thought might be more than European law would require, and the Court of Appeal's version was at 768, and that's the one which we're now working to. And that's paragraph 107. So it therefore falls to this court to determine the appropriate conforming interpretation. In our judgment, a conforming interpretation can be achieved simply by reading in words that make it clear that resident companies can claim a credit under section 231 in respect not only of qualifying distributions made by resident companies, but also distributions made by other companies to the extent that the community law requires a tax credit to be given in respect, to the extent of the tax credit given by community law. So that's the difference. So if, for example, there were a dividend of 1,000, under Mr. Justice Henderson's version, it would automatically carry a credit of 25. And what the Court of Appeal was saying is, no, you have to see what credit the CJEU gives. Now, we know from the second reference that that is the actual tax paid or the foreign nominal rate, whichever is the higher. So that is the only difference. In practice, it has made no difference, but it could have made a difference. And I hope that clarifies the position for my Lord. And Lord Reid asked as one of the questions for us to consider whether
Mr. Evanson, thank you very much for that. My reading was that it would mean that the recipient company's FII would be would give a tax credit at the UK rate of 25% in respect of the UK dividends it received, and a tax credit at the rate of the FNR in respect of foreign dividends. That would be the effect of it.
As long as the FNR was not higher than the UK rate, yes.
Yes, subject to the UK rate cap.
Exactly.
Thank you.
That has it. Well, may I move to my Lord Reid's question about, well, if the payment of the shareholder credits isn't to be taken as a diminution, but is instead to be treated as a change of position. What is the situation? The situation is that that is exactly what the Revenue's case was in the second High Court hearing. And I can explain very briefly and then take you to it. It's a fairly extraordinary episode here. The second High Court hearing, which lasted 16 hearing days, heard expert testimony from two experts for the Revenue, one Professor Miles, who was an economist, and the other was Sir Jonathan Stevens, who was a very distinguished civil servant who had worked in the Treasury. And they gave their evidence, and we had Mr. Sentence giving out evidence, his opinion to the contrary, on the questions of whether there was a change of position or whether there was enrichment. So they gave their evidence, and both issues were in issue. What happened was that the issue of the shareholder credits was dealt with in the expert testimony of Sir Jonathan Stevens. And he was saying that the ACT system, you pay your ACT and it gets paid out straight away as a credit. That evidence was not accepted by Mr. Justice Henderson for the reason that it was improperly given. And I'll take you to the passage. It was an extraordinary part of this case. And Mr. Hewitt explicitly disassociated himself from that part of the evidence. And the reason it was improperly given is that it wasn't his evidence at all. He was simply signing what had been written for him by presumably someone in some team in the revenue or whatever. I can take you to that. So this point did come up. It actually has been held as a fact that there was not a change of position, although it being held in principle that the revenue could argue it, held as a fact they had not made good that proposition, and I believe they were refused leave to appeal on the factual findings. I'm pretty sure that's right. So the matter has been dealt with. It could have been dealt with. And then it was dealt with by Mr. Justice Henderson as a separate issue conceptually, whether there was enrichment or not enrichment. And for the reasons which we've been through, he held in our favour. You'll find the reference to that in the in Appendix 1A, Divider 17, at EF 1376. You see, 1376, issue 20, have the revenue made out a defence of change of position on the facts? And then 342, on the assumption that it is in principle open to the revenue under English law to rely on change of position as a defence to the state-based claims, subject to the question considered under issue 21 below whether such reliance is precluded by EU law, the present issue asks whether that defence has been made out in the facts. We go to page 1381 at 360. You'll see the expert witnesses who gave evidence on government finances at the resumed trial were for the revenue Sir Jonathan Stevens and Professor Gareth Miles, and for the claimants Dr. Sentence. No separate evidence of fact was adduced on either side. I have already referred to Sir Jonathan's relevant experience and expertise in the context of what he had to say about the linkage between ACT and tax credits. See paragraphs 283 to 287 above. So this was in the context of Mr. Justice Henderson considering the change of positions offence. He said, I've already told you about that. You go to 283 to 287, which is on page 1358. Let me read from paragraph 282. 1358. It's unnecessary for me to pursue these matters any further. As I've said, I'm satisfied that under English law, the revenue were indeed enriched by the full amount of the unlawfully levied ACT. There is, however, one aspect of the evidence on this part of the case which calls for comment. One of the revenue's expert witnesses was Sir Jonathan Stevens. Sir Jonathan's a very distinguished public servant. He is a permanent secretary rank in the civil service, currently works in HM Treasury reviewing arrangements for public sector. We dropped down to 285. In the first section of his report, however, he discussed the operation of the ACT system, and you recall from the earlier passage, a few pages later on, that was the passage linking ACT and tax credits. So he discussed the operation of the ACT system and addressed the question of whether the government was enriched by receipts for ACT. He outlined the way in which he understood the system to operate and concluded that the government was not enriched. Under some justifiably severe cross-examination from Mr. Aronson, it soon emerged that this part of Sir Jonathan's report was not based on his own knowledge or expertise and amounted to little more than a presentation of arguments supplied to him by the revenue. It was not a subject on which he was personally equipped to offer an expert opinion. As evidence, therefore, this part of his report was valueless, and in his closing submissions, Mr. Hewitt rightly made it clear that he placed no reliance on it. And the learned judge then went on to read the Riot Act about the role of expert witnesses. So the point was raised by the Revenue and dismissed, and indeed disavowed by the Revenue's own counsel because of the way in which the evidence had been presented. And that matter is no longer an issue. May I move on to UFTs and really repeat what I said before, but I can summarize it very briefly. I mentioned in my opening that the chronology here was important, and that when Mr. Justice Henderson was considering what the discrimination was, what the restriction was, he was at that stage assuming that the discrimination was a failure to accord the exemption to foreign dividends. And I said he said so in terms, I didn't actually refer you to the passage. It is at EF 1019 at paragraph 62. You'll recall at this stage of the hearing, he was dealing with our argument that the effective rates of tax were indeed systematically lower and not just in exceptional cases lower. And he had heard the evidence and concluded that that was unquestionably correct. Paragraph 62, Mr. Justice Henderson says this: it also seems to me to be implicit in paragraph 55 that had the ECJ been satisfied that the differences between the nominal and effective rates of UK corporation tax were not highly exceptional, they would have agreed with the Advocate General that the exemption system for UK domestic dividends treated them more favourably than foreign dividends. So his assumption at that point was, having heard the evidence, and he didn't need to hear it, he had been the Revenue Standing Counsel, he knew full well that effective rates were much lower than normal rates in the UK. But having heard the evidence, found as a fact that that was the case, his assumption was the ECJ was going to say in which case the imputation system was precluded and the exemption system should be applied. So it's in the light of that he regarded the restriction as being the failure to accord the exemption system. I'm saying that's really just his approach. But whether that's right or wrong, I submitted is actually, that is the correct view of how the learned judge was approaching it. The simple fact remains that the restriction we are dealing with was the restricted amount of credit that was allowed. And unless you take the most extraordinarily high level of generality and say, well, you weren't allowed enough, and they weren't allowed enough to begin with, and they weren't allowed enough after use, and that's enough. Unless that is the level of generality to determine whether something is in substance identical, we have to succeed on this issue. And my learned friend, again, in his response, said, well, A deals with this. But as I pointed out in A, the restriction as applied to the Swiss company's dividend was totally unchanged from 1992 right the way through to the date of the claim. There wasn't one detail that changed. In our case, everything changed. My learned friend prays in aid the argument, well, if I'm right on this argument, then surely a rate of tax change would have the effect. No, that can't be right. It isn't sensible. What matters is the set of rules applying to the foreign dividends to which a rate of tax is applied. It's those set of rules. If they change and make the tax burden higher, and they've changed after the 31st of December 1993, that brings an end to the standstill. If the general rates of corporation tax go up or down, that makes no difference. It's the rules to which the rates of tax apply. Of course, if there were a discriminatory tax, if after the 31st of December and there is no deal, we impose a tax higher on foreign dividends than on UK dividends, actual rate of tax, that would be discriminatory. were we still subject to EU law? But that isn't the proposition that my learned friend put to you. What my learned friend said is, well, if I'm right, if the rate of tax goes up, then the rules are not identical. The rules are identical. The restriction is identical. The restriction of the rules to which the rate of tax is to be applied. And so I repeat my submission that this really is a no-brainer. There is no question whatever that the restriction as applied to the foreign dividends in our system, the restriction was significantly and intentionally increased. Which takes me to my Lord Aubrey's question about whether it is the case that that giving an imputation credit under section 231 is sufficient for us to succeed on our shareholder credit, the treaty credit claim for the Ford company. And the answer is yes. And the two cases which my learned friend cited, each of them respectively confirms the two propositions I made in this respect. You may recall my propositions were this. I said that EU law, the logic of the section 231 credit given by EU law, the logic of that meant that the treaty credit was due. And if it was due, then there was no disenrichment by the revenue. I said, that's the logic. And that is correct. And I will show you why that is indeed confirmed by Corelli itself in the House of Lords, or by dicta. That's the logic. What I also said was that the shareholder credit in the UK, which is issue 17, that was mandated by EU law additionally, because that's the whole concept of the underlying the alleviation of economic double taxation, as was discussed by some of your lordships this morning. That was mandated, and we know that was the case because that was laid down in the BT pension fund case as an explicit confirmation of that point. So for dividends distributed to UK shareholders, both the logic of the system underlying section 231 and the explicit additional requirement mandated the giving of the credit to the shareholders. In the case of the US shareholders, it is only, but it is sufficient, it is only the logic of section 231 that gives them. There is no additional right, because EU law does not give them the additional personal right, one might say, explicit right to receive the credit. Now, I can show you that by going to the two cases my learned friend referred to, the test claimants in the ACT group litigation, class 2 and 4, and that's in A7. No, wait a minute, I get the actual ECJ. Here we are. It's A9 at 100. And you will divide 100, A9, and it's EF page 6370. All I need read really about 2 or 3 short sentences to explain how this engages. So if we go to 6370, A9 100, you'll see the name of the case. You'll see the judges, all the heads of presidents of chambers were the same. The decision was given on the same day as the FII case. It was the same Advocate General. The cases were heard 1 week apart, and as it happens coincidentally, Pirelli in the House of Lords was heard in the days intervening. It was a rather hard-working week. But if one then turns to Advocate General Hill Hood at 6375, in paragraph 1, we can skip over the first 6 lines of that, turn to the first 2 lines of 6376. Put otherwise, this is the question, put otherwise, in what, if any, circumstances do Articles 43 and 56 oblige Member States to grant tax credits to recipients of outgoing dividends? That was the question. In what circumstances, if any, does the freedom of establishment or the freedom of movement of capital oblige Member States to grant tax credits to recipients of outgoing dividends? In other words, to Italian or whatever shareholders of UK companies. If we go right to the other end of the case, in the ECJ, to page 6416, you get the answer. A lot of stuff in the middle explaining why, but the answer is very short and straightforward and explains why the other case came to be heard. The answer is 1. Articles 43 and 46 do not prevent a member state on a distribution of dividends by a company resident in that state from granting companies receiving those dividends, which are also resident in that state, a tax credit equal to the fraction of the corporation tax paid on the distributed profits by the company making the distribution, when it does not grant such a tax credit to companies receiving such dividends which are resident in another member state and are not subject to tax on dividends in the first state. That was their answer. So it's saying there's nothing wrong with giving a tax credit to UK residents if you're a UK company and not giving it to Italian residents if that dividend isn't subject to tax in the UK. So it was one of those answers that raised more questions than it answered. What's it mean by saying the dividends are not subject to tax in the UK? And it's in that context that the cases in A7 at page 5639, so it's A7 tab 78, it's in that context Ms. Justice Henderson's 77 at 5639. She's just from the what you see on the label is what you've got in the can. This is the case that's come back to the UK after the CJEU gave that short answer. So this is test claimants in the ACT group litigation, classes 2 and 4. And if you go to here to what this case is asking is, well, does that mean you do get a tax credit if the dividend is subject to tax? And the dividend is subject to tax in a way, and you see this in the Court of Appeal, doesn't come so clearly from Ms. Justice Henderson. If you turn to 5686, which is behind tab 78, if you turn to page 5693, you'll see in Lord Newberger's judgment at paragraph 18 in the middle of the page, in several such double tax conventions, the UK has agreed that non-UK resident shareholders in UK companies should be entitled to a tax credit in respect of dividends paid to them by a UK resident company. If you drop down to below the citation, you'll see the sentence, Article 10.3a of each double taxation convention also empowered the UK to charge tax on the aggregate of the dividend and the tax credit at the rate of 5%. So that's why the question was raised. We saw the answer of the CJEU, saying there's no obligation to give a tax credit to an overseas shareholder unless the dividend's taxed. Well, the dividend was taxed at 5%. And it's in that context that the argument was raised by us just to see what the ECJ meant. Does that mean that a full tax credit has to be given to the Italian shareholders? Is that what it means? The answer reached by Mr. Justice Henderson in the Court of Appeal was no, because the 5% was really just part of the calculation of the tax credit, and it wasn't really a tax in the sense that the CJEU meant. Perfectly, with great respect, a perfectly plausible conclusion to reach. But until that conclusion was reached, we didn't know what conclusion was going to be reached. We said it should be referred back to the CJEU. They decided that it didn't need to be sent back to the CJEU. It was sufficiently clear. I'm not sure if Lord Briggs is saying something.
No, I was just muttering to myself, Mr. Evans.
Ah, that's why the hand wasn't raised. I saw the lips moving, but not.
One of the few advantages of doing it remotely than doing it face to face.
Anyway, that is the explanation as to what those cases were about. It was testing a proposition. You go off to the CJEU, you get an answer, you say, oh my heavens alive, what does this answer mean? We've got one in FII we don't understand, we've got one in ACT class 4 we don't understand. So this wasn't a silly argument we were raising. We could have succeeded. It needed to be tested. I said that was one of the two propositions I raised. The second proposition was that the logic of Section 231 itself is sufficient. And that emerges from Pirelli itself, Pirelli case. That is in A1 at 13. And if one turns to electronic page 3488, you see this conveniently at paragraph 39 of Lord Hope's speech. Go just above it a little bit, but I do not think that this approach fits either with the clear language of Section 231 itself or with the system which the tax credit mentioned in that section is designed for. It seems to me that there's no escape from the fact that it's Section 231 that Section 7883D uses to identify the relief that is to be given in accordance with the DTA by way of a relief under the domestic system of non-resident companies. It was the domestic system, not the treaty, that defined the extent of that relief. Exactly, it's Section 231. And we know in Pirelli that the reason 231 didn't apply was because Section 247, dealing with group income elections, disapplied 231. That's what the case was about. Nothing to do with European credits. It's all to do with the disapplication of Section 231. And the same point is made very clearly by Lord Scott at paragraph 67 at 3496. It follows, in my opinion, from Section 231 and Section 2472 that where a group income election is in force and dividends are paid by a UK company, a Section 231 tax credit cannot be claimed by the recipient of the dividends. The language of Section 231 and Section 2472 bars such claim. And for that reason, the Italian shareholder doesn't get the credit. Take away Section 247, 231 does apply, feed in the European credit, the shareholder does get the credit. Well, the only other comment I would make is my learned friend did make some comment about foreign subsidiaries maybe not paying tax, just looking at the foreign nominal rate rather than the actual tax paid. It just happens that all the subsidiaries there did actually pay tax at a sufficient rate to cover the Section 231 credit. It doesn't make any difference, but that is factually the case. So, well, as I say, as far as a issue 15 is concerned, the overseas shareholders are entitled to the treaty credits because of the operation of section 231, where the credit has been fed in from the overseas corporation tax, and everything follows through. And unless I can assist your lordships further, those are my submissions on the points open to me. I can't hear you, my lord already.
I'm sorry, it works better if I unmute myself. Thank you very much, Mr. Aronson. We'll turn then to Mr. Bremner.
I'm grateful. Look, may I please start with issue 11, Court of Appeal 2. That's the surrender issue. What is critical here in my submission is this court's ruling in Prudential at paragraph 110, which one will see at electronic page 3552 within Authorities Volume 2. That's the point of principle. And the question is, how far does that principle go in this context? The conclusion is that lawful ACT isn't set against unlawful MCT. And that meant that the pro rata method couldn't work, precisely because that method involved unlawful MCT being met in part by unlawful ACT and in part by lawful ACT. And that was contrary to the ruling that the court had given on issue 3, because that ruling had been that the lawful ACT was still available for use under section 239. That was why the restitution claim in issue 3 in Prudential failed. And so the principled answer which the court identified came from the insight that both the unlawful ACT charge and the unlawful MCT charge are nullities. And one sees that at the top of page 355, page 3555, still within para 110. And that then gives the method. If one reads further down in paragraph 110, the unlawful ACT is treated as having been utilized first against the unlawful MCT. And then when there's no unlawful MCT against which to set the unlawful ACT, the residual unlawful ACT is to be treated as utilized against lawful MCT. That's the method for the single company situation. In my submission, exactly the same solution applies in the group context. Now, my learned friend sought to suggest that it was fundamentally wrong to say that there was no surrender or utilization. My response to that is that cannot be reconciled with this court's analysis in Prudential. The unlawful charges are nullities. That's the case both for the unlawful ACT and the unlawful MCT. And the unlawful ACT being a nullity, it does not have any legal significance for the purpose of section 239 and section 240. So there was, in law, no effective surrender, just like there was no effective set-off. What we're doing now is a computational exercise working out what amounts of unlawful ACT should be treated as utilized against which amount of MCT. And of course, the relevant claimant is always the company that paid the ACT. And your lordships will recall the point that the unlawful ACT is a nullity. That, of course, also underlies my secondary case on the Sempra issue. Because there also, the unlawful ACT didn't exist, no effective set-off, contrary to what my learned friend was submitting this morning. And so even if I was wrong on the Sempra issue about my main submission and about the procedural bar to the claim falling, section 35A would apply on any view, applying the nullity analysis. Now, my learned friend also tried to make the point that when you surrender, you don't know what you're going to utilize against. But that's exactly the same point that he made to this court in relation to the payment of ACT in the context of the utilization issue, issue 5A in Prudential. He said, in the context of that issue, that because it was an undifferentiated fund, and that was the submission that the Court of Appeal had accepted, recorded at paragraph 109 in this court's judgment, page 3554, he said because it was an undifferentiated fund, when the ACT was paid, the taxpayer couldn't and wouldn't know how it was going to use the ACT. And that point was rejected in Prudential. I say that surrender produces exactly the same outcome. All that is happening on issue 11 is the same principles apply in a group context, and that gives a principled and straightforward solution. If there's a surrender of a mixed payment of lawful and unlawful ACT, you associate the unlawful ACT surrendered with the unlawful MCT against which it was utilised. Now, Malone, he didn't develop the example that he put in his written case orally. I dealt with it in my response. I'm not going to say any more about that point. I say, in summary on issue 11, Prudential gives a principled answer, and that answer applies to the surrender situation as well. That's issue 11, Court of Appeal 2. May I please now deal with the question that Lord Reid raised this morning as to the rationale of Section 85, and particularly the dates that were chosen. And the Court will have seen we looked up the explanatory notes submitted to the Court, and hopefully the Court has those to hand. It's just a very short two-page extract. At that time, it was still 84 and 85. And you see in the background note at the bottom of internal page 244, and the same point is made in the background note to clause 85, page 255, that this provision is seeking to address uncertainty that has arisen for both taxpayers and HMRC following Prudential. So it's dealing with uncertainty. The remedy is non-exclusive. It says that in terms in paragraph 1 of the explanatory note, and that, of course, is reflected in section 86, sub 2, as we saw yesterday. In my submission here, Parliament is working on the basis that there may be a remedy. The Court has my submission yesterday that there is a remedy. Indeed, there must be a remedy, quite apart from section 85, which has existed prior to its enactment. And what section 85 cannot, in my submission, on any view do, is cut down or restrict the domestic law remedy, which in my submission previously existed as a result of this Court's judgment in Prudential. And you've got my submission as to why that must be the mistake-based restitutionary remedy. On the date specifically, my learned friend pointed this afternoon to the date of FII ECJ1 and made various points about the date at which the ACT system came to an end, all of that. I say that these dates are all inevitably backward-looking, and they are arbitrary, and it reinforces why our remedy cannot be cut down with retroactive effect. What I say is that Section 85 is an additional remedy, and what I object to is it cutting down the remedy that previously existed in English law, and the Court also has my submission about its inability to provide any remedy at all for the pre-1996 or on any view the pre-1993 periods. So that's what I'd say about this date. May I please make a small correction to what my learned friend said about Rhodia? This was in the context of the potential applicability of the restitution interest charge, that's Part 8, capital C, Corporation Tax Act 2010, in relation to Section 85 interest. My learned friend suggested that in Rhodia there was no restitution interest in relation to Section 85. That isn't right. There were two claimants in the Rhodia case. There was one which just had an award of Section 85 interest. It is true that in that context, Part 8C doesn't apply. The problem that arose in Rhodia, and the problem that would arise in this case, is that there was a second claimant in Rhodia, and the second claimant obtained an award of interest which included interest both under Section 35 capital A That was because it had a claim to recover overpaid D5 tax, and it also had an interest award under Section 85. It had a FID claim. And the consequence, and we explain this in paragraph 168 in our case, and it's section 357, capital Y, capital C, sub 4 and sub 5 that do this, is that on the revenues view of the world, and you can see the force of it when you look at the statutory provisions, although it's no doubt a point that one might wish to argue about, that if there is any element of an interest award, if there is any element of an interest award other than at a statutory rate, and the revenue is saying that section 35 capital A is not at a statutory rate, then the ring-fence restitution interest tax applies to all elements of the interest award. That's the correction I'd make in relation to Rhodia. The order is in the bundle, and it starts, I don't think we need to turn to it, but it starts at electronic page 1745. The relevant recital is recital capital D, Roman 5, little c, and the court will have that at electronic page 1747. That's the recital that relates to the second claimant. There is an irrelevant recital, which is little a, which says that a particular amount cannot be restitution interest. That's an amount relating to the first claimant, which seems to be the claimant that my learned friend is talking about. But that's not the claimant that we had in mind. The problem in Rhodia arose in relation to the second claimant, who had the award both under section 35A and under section 85. So I hope that clears that up. It's a point of detail.
And this is what we're looking at is an order that this court made of consent of the parties a few days ago.
Yes, this is 4th of June 2020.
Oh, well, there was an order we made, I think, on Monday of this week.
This is a High Court order, I think.
Ah, that's it. That must be the explanation.
Not sure I'm looking at the same thing as your lordship. May I ask what page of the bundle your lordship is on?
Oh, I may have been under a misconception. I was looking at 1745, and I see, yes, Lord Hodge is quite right. This is an order made by Mrs. Justice Falk.
Exactly so.
Rhodia, we made a. I thought that might be it.
Oh, I think that may be a different order. That,
yes, it must be.
That certainly I'm not familiar with.
Yeah.
Those who are virtually sitting behind me say that order that your lordship has in mind is not to do with this issue.
Fine.
It's the one at page 1745. Mrs. Justice Falk's order. That's the relevant one for my purposes. So that is the point on Rhodia. Can I go next, please, to my reply submissions on issue 11 and 13, Court of Appeal 1. That's the question of relief. Now, on this, there is now no debate of principle and no opposition by the revenue to the point that the principle recognised by the Court of Justice in Salonen applies in this case. I explained that in detail yesterday. It was essential to avoid the indirect economic double taxation of the dividend, and in Salonen that involved a requirement to carry double taxation relief forward. The debate that remains is how one gives effect to the requirements of EU law as set out in Salonen in this case. Now, my learned friend suggested this morning that the carry forward of double taxation relief, it might be more restricted, he said, than a carry forward of particular management expenses, was what he was focusing on at the time. Now that can't be right, because it doesn't respond to the vice that was identified in Salonen. The problem that the Court of Justice identified in Salonen is the indirect taxation of the dividend income through the taxation of the year 2 profit. And it, in that case, was the Austrian legislation which failed to enable the carry forward of the credit that was precluded. And the court has my submission that exactly the same right is exhibited by the UK legislation. And I took you through the examples in our case, demonstrating that the year 2 tax is the indirect taxation of the year 1 dividend income. And it follows in my submission that the taxpayer must be able to apply the double taxation relief against the year 2 profit. Now, my own friends sought to move away from that or outmaneuver that by saying, oh, well, there can't be a restitution claim for year 1 tax. That's not an answer to his restitution claims. We can look at the pleadings if the court really wants to, but perhaps I can just give you the references. The claim for the year 2 tax is pleaded in paragraph 17, capital G, capital A, of the particulars of claim, and particularly subsection E, within that rather long paragraph. The court will find that at electronic page 1973, and that is introduced by a specific reference to the principle in Salonen, which is identified at subparagraph C within paragraph 17, capital G. So that's the claim. There's no problem with the claim having been made. The greater detail on this is set out in our case, where we make clear that what's being sought on this analysis is the year 2 tax. That's paragraph 111 in relation to the management expenses. It's paragraph 115 for group relief, and the references for that are electronic page 417 and 419, respectively. Now, on group relief, in the context of issue 11 and 13, Court of Appeal 1, Milano Friend tried to rely on the point that group relief couldn't be carried forward domestically. He tried to say, oh, well, we're just treating an overseas situation the same as if a mistake had been made in a UK context. No, that's not an answer. What is having to be done here is to effect the restoration of equivalence with the exemption system that applied to domestic source dividends. In the domestic context, because of the exemption that applied to that income, there would be no question of applying any relief at all. The question of using reliefs would simply never arise. So it isn't an answer to point to what might happen if some UK company mistakenly surrendered group relief, messed up its group relief claims, words of that nature. That's irrelevant. Milano Friend's approach doesn't restore the necessary equivalent treatment. All that group relief does is shift the timing of the tax liability and the identity of the tax-paying company. And that makes no difference of principle. As I submitted yesterday, we know that from the ruling on the second reference on group income elections. Milano Friend sought to brush that aside this morning, but he offered no reason of principle for there being a different outcome. So in my submission, the revenues approach, which seeks to cancel the management expenses and to strand the group relief, they are not permissible courses, and rather the conforming interpretation which the claimant suggests gives a principled answer, and that grounds the restitution claims that have been pleaded. So those are my submissions on issues 11 and 13. There was a procedural point about the SID summary judgment. I wonder if I should just very briefly make sure that my position is clear on that. There seems to be a suggestion that the court should set aside the summary judgments that were given on the SID claims. That's not an appropriate course. Milano Friend doesn't have permission to make that point in any event. What we have at issue here is a question of how those summary judgments should be quantified. And in that context, it is very important that the revenue, having withdrawn various concessions, has replaced the previous concessions with a new concession, which is that Section 85 interest would apply on those FID claims. And as it happens, when one does the arithmetic, one would find that in very large measure, the quantum of the claims would not be affected. So all that needs to happen, and this was the burden of the correspondence that my solicitors sent to the court on Thursday, is that for the purposes of quantification, the matter should be remitted to the High Court. But there can't be any question, in my respectful submission, of the summary judgment being affected. Can I make two final points? One of more general nature and one very specific. There was a point made this morning in the context, I think, of the relief submissions, that British American Tobacco had paid very little UK tax over the course of the period 1973 to 1999. Just so there's no misapprehension, those behind me have checked the figures. In the period 1973 to 1999, BAT paid £1.3 billion of UK tax. Of the 1.3 billion, 277 million is unlawful. I don't want there to be any misapprehension about the figures. That was the general point. And may I lastly just ask one specific question, which is to check. I hope the court received from me this morning a short note dealing in a little more detail with the answer to the question that Lord Briggs put to me yesterday afternoon about the retrospective revocation of patents. I hope that came through safely, and I hope it's been of some use.
Yes, thank you very much.
Thank you.
Well, would you just give me one moment? My lord, unless I can assist further, those are my submissions.
Well, the court is very grateful to all counsel and to the many people who've been metaphorically sitting behind you for presenting your submissions so efficiently to us and with as much clarity as the subject matter perhaps allows. We'll now try to make as much sense of it as we can and issue a judgment in due course. In the meantime, the court will adjourn.